Welcome back to the channel. Today we are diving into one of the most essential topics for your Paper 3 exam, the capacity of minors. In the eyes of the law, not everyone has the power to bind themselves to a contract. But while the general rule says minors can't be sued, there are huge exceptions that the examiners love to test. Whether you're looking to master the Necessaries test or understand how the Minors Contracts Act 1987 changed the game, this is your ultimate guide to securing those top band marks in contract law. Grab your notebooks, let's break down the law of capacity. To understand capacity, we first need to look at the general rule. In contract law, we assume that adults, those 18 and over of sound mind, have the full freedom to enter any agreement they choose. However, under the Family Law Reform Act 1969, anyone under the age of 18 is legally a minor. Because the law views young people as potentially vulnerable, they have what we call limited capacity. Now, the rules governing minors are a bit of a legal hybrid. They're built on centuries of common law, but were refined by the Minors Contracts Act 1987. A great way to remember the policy behind these rules for your essays is the shield, not a sword, principle. The law acts as a shield to protect minors from their own inexperience and from being taken advantage of by adults. But it isn't meant to be a sword that allows minors to unfairly exploit businesses by getting goods for free. As we go through this video, you'll see how contracts sit on an enforceability scale, ranging from those that are fully binding, like necessaries and service, to those that are voidable or completely unenforceable. Let's look at the first big exception, contracts for necessaries. Now, let's get into the technicalities. The general rule is that contracts made by minors are voidable at the option of the minor. But as a law student, you need to be careful. The word voidable is actually used in two different ways here, and mixing them up can cost you marks. First, some contracts are voidable in the positive sense. This means the contract is binding from the start, but the minor has a right to opt out or repudiate it. To do this, they must act either before they turn 18 or within a reasonable time after reaching the age of majority. If they don't say anything, the contract stays valid. On the flip side, most other contracts are voidable in the negative sense. These are essentially not binding on the minor at all. They only become enforceable if the minor chooses to ratify them, which basically means giving a fresh thumbs up to the agreement once they turn 18. Understanding this distinction is key to answering problem questions, as it determines whether the minor is already on the hook or if they have to opt in later. Next up, let's look at those specific exceptions where the rules change completely. Now we're getting to the heart of the matter. While we just established that contracts with minors are typically unenforceable, there are four major categories where the law can create legal obligations. These are the exceptions you must memorize for your Paper 3 problem questions. First, we have contracts for necessaries. These aren't just things you need to survive. They are essential goods and services relative to that specific minor's station in life. Second, there are beneficial contracts of service. The law wants to encourage young people to work and learn, so employment, education, or apprenticeship agreements are usually binding, provided they actually benefit the minor. Third, we look at voidable contracts. These involve long-term interests like leasing a flat or buying company shares. These are valid and on by default, unless the minor actively opts out or repudiates them. And finally, we have unenforceable and other contracts. These are your standard everyday agreements that don't fit the first three categories. While the minor isn't bound to pay, stay tuned, because we'll see how the court uses its power of restitution to make sure things stay fair. Let's dive into the details of our first exception, necessaries. First up, contracts for necessaries. This is the most common exception you'll see in exams. The law recognizes that minors need to buy basic essentials, so they are under a legal obligation to pay for them. But here's the catch. They only have to pay a reasonable price, even if the contract says something much higher. So, how do we define a necessary? We look to Section 3 of the Sale of Goods Act. It gives us a two-part definition. First, the goods or services must be suitable to the minor's condition in life, their social and financial status. Second, and most importantly, they must be necessary to their actual requirements at the time they bought them. When a case like this goes to court, the judge uses a two-stage test. 1. The question of law. Is this item even capable of being a necessary for someone in this minor's social class? The person suing the minor, the claimant, has to prove this first. 2. The question of fact. Even if it could be a necessary, was it actually necessary for this specific minor right then? 3. As we'll see in our next slide with the famous case of Nash v. Inman, you can have the fanciest clothes in the world, but if your wardrobe is already full, they aren't necessaries in the eyes of the law. Let's look at that classic case now. To see how this two-stage test works in the real world, we have to look at the classic case of Nash v. Inman. The facts are quite famous. The tailor supplied an undergraduate student at Cambridge University with a large amount of clothing, including 11 fancy waistcoats. When the student didn't pay, the tailor sued, claiming these were necessaries. Now, apply the test we just learned. The court looked at his ruling in two parts. First, were the clothes suitable to his station in life? The court said yes. As a Cambridge student in 1908, fancy waistcoats were typical for someone of his social status. But then came the second hurdle. Were they actually necessary for his requirements at the time? Here, the tailor's case fell apart. It turned out the student's father proved that his son already had an ample supply of clothes. Because he was already well-stocked, the 11 extra waistcoats weren't necessaries, they were luxuries. The outcome? The tailor's claim failed. This case is the perfect example for your exam to show that suitable does not always mean necessary. If a minor is already well provided for by a parent or guardian, an adult trader will find it almost impossible to win their case. Next, let's switch gears and look at how the law treats minors who are entering the workforce. Beneficial contracts of service. Next, we have our second major exception. Beneficial contracts of service. The core rule here is that minors are legally bound by contracts for employment, apprenticeship, or education. Why does this rule exist? Well, think about it from the law's perspective. It's actually in a minor's best interest to be able to enter the workforce. If these contracts weren't binding, employers would be terrified to hire young people. The law wants to ensure minors can acquire the skills and the means to earn their own livelihood and become independent. But there is a safeguard. The court applies what we call the global test. This means they look at the contract taken as a whole. They aren't just looking for one bad clause, they are looking at the entire deal to see if it truly benefits the minor. The balance is key here. A contract might include some harsh or restrictive terms, maybe a low starting wage or a clause that stops them from working for a rival. But if the overall package of training, experience, and wages is beneficial, the contract remains binding. It's all about whether the minor is being empowered or exploited. To see this balance in action, let's look at a case involving a professional athlete, Doyle v. White City Stadium. Here are the facts. Doyle was a minor who held a professional boxer's license. During a fight, he broke the rules and was disqualified, so the promoters withheld his prize money according to the contract. Doyle sued, arguing that because he was a minor, the contract was unenforceable and they had to pay him. But look at the court's ruling. They didn't just see this as a sports agreement, they treated the license as a contract of apprenticeship. The reasoning is the most important part for your exam. The court admitted that the no prize money rule was harsh, but they applied that global test we just talked about. They decided that taken as a whole, the license was beneficial because it allowed Doyle to box professionally, gain specialized training, and earn a living in the long run. The outcome? The contract was held to be binding. Doyle couldn't use his age to escape the rules of his profession. Now we come to our third exception, voidable contracts, specifically those involving continuing obligations. Think of this as the long-term interest rule. This category doesn't cover buying a chocolate bar. It covers contracts where a minor acquires a permanent or long-term interest in something that carries ongoing duties. For your Paper 3 exam, you need to memorize these 3 key examples. 1. Leasing property, like a tenancy agreement. 2. Purchasing company shares, where you might have to pay for future calls on those shares. 3. Entering into a partnership, where you share business liabilities. The law handles these with the repudiation rule. These contracts are actually binding by default, unless the minor takes the active step to repudiate, which is just a legal way of saying cancel the agreement. But watch the timeline. This is where many students lose marks. Repudiation must happen either during their minority or within a reasonable time after they turn 18. What is reasonable? That's for the court to decide. But if the minor does nothing and continues to enjoy the benefits of the contract after they become an adult, the contract becomes fully enforceable and they can no longer back out. Next, let's look at the case law that defines exactly what reasonable time looks like and what happens to any money already paid. To really master voidable contracts, you need to understand the consequences of waiting too long to act. We have two heavy-hitting cases here. First, let's look at Edwards v. Carter. In this case, a minor tried to repudiate a marriage settlement, basically a financial agreement, but he waited 4.5 years after turning 18 to do it. The House of Lords was very clear. This was far too late. It wasn't within a reasonable time, so he remained bound by the contract. This shows us that reasonable is usually measured in months, not years. Second, we have Steinberg v. Scala Leeds Limited. This case answers a crucial question. If a minor cancels a contract, do they get their money back? Here, a minor bought shares and later repudiated the contract to avoid making future payments. The court allowed her to cancel the contract to stop future liability, but they refused to give her back the money she had already paid. Why? Because she had already received the shares. Even if she didn't make a profit, she received something of value. Here is your gold standard exam tip. In these continuing contracts, a minor can only get their money back if there is a total failure of consideration. This means they must have received absolutely nothing in return for their cash. If they got any benefit at all, the money they've paid is gone for good. Now, let's wrap up with our final category and the legislation that protects adults. The Minors Contracts Act, 1987. Finally, we have to look at the safety net for adults. The Minors Contracts Act, 1987. Before this act, the law was a bit lopsided. Minors could often keep goods without paying a penny. To fix this imbalance, the 1987 Act introduced two game-changing sections you need to cite in your essays. Section 2, Guarantees. This makes it safer for businesses to deal with minors. It states that if an adult acts as a guarantor, they are legally bound to pay if the minor doesn't, even if the underlying contract with the minor is technically unenforceable. Section 3, Restitution. This is the Fairness Clause. If a minor gets hold of property under an unenforceable contract, the court has the power to order them to return the goods. It ensures that while a minor might not have to pay, they don't get to keep a windfall for free. To see how the court categorizes modern contracts, look at the key case of Proform Sports Management v. Proactive Sports. The facts. A 15-year-old Wayne Rooney signed a representation deal with a sports agent. Later he tried to move to a different agent. The ruling. The court held that this wasn't a beneficial contract of service because the agent wasn't providing training or education. They were just managing his business affairs. It also wasn't a contract for necessaries. The outcome. Because it didn't fit those special categories, it fell into the other category and was held unenforceable against Rooney. This case is a perfect modern example to show that just because a contract is good for a minor's career, it doesn't automatically make it binding. And that wraps up our look at capacity. Stay tuned for our final evaluation summary. To hit those top-tier marks in Paper 3, you can't just state the law, you have to evaluate it. Our first major evaluation point is the paternalistic nature of English law. In legal terms, paternalistic means acting like a protective parent. The law's primary goal here is to shield minors from their own lack of experience and from unscrupulous adults who might try to exploit them. The evidence? Just look at the general rule. By making most contracts voidable or unenforceable at the minor's option, the law shifts almost all the financial risk onto the adult party. The minor has the power to walk away. But here's your critical analysis for the exam. While this protection is great for preventing debt, it can actually backfire. Think about it. If you were a shopkeeper or a landlord, would you want to trade with someone who can legally cancel the deal at any time? This legal shield can make adults reluctant to do business with young people. This potentially disadvantages young entrepreneurs or independent 16 and 17-year-olds who genuinely need to buy supplies or rent a place to live. By overprotecting them, the law might actually be limiting their economic freedom. It's a delicate balance. Is the law a helpful safety net or an outdated barrier to independence? Moving on to our second evaluation point, defining necessaries, clarity versus uncertainty. While the law tries to be helpful by allowing minors to buy essentials, the definition under Section 3 of the Sale of Goods Act 1979 is actually quite flexible, which leads to legal uncertainty. The evidence? Look back at Nash versus Inman. The court's distinction between an item being suitable and necessary creates a massive gray area. A tailor or a shopkeeper might see a well-dressed student and assume they are making a valid sale, only to find out later that the student's wardrobe was already full. This puts an unfair burden on the adult trader to investigate a minor's private life before selling them anything. Now, For the critical analysis, while the reasonable price rule is a great safeguard to prevent minors from being overcharged, the station in life test is often criticized for being outdated and elitist. Think about it. This test implies that what is necessary for a wealthy student might be a luxury for a working-class teen. In a modern legal system, should your social class determine your contractual rights and liabilities? Many legal scholars argue this standard is a relic of the Victorian era and doesn't fit our modern values of equality. It's a classic exam debate. Does this flexibility allow for justice, or does it just create confusion and class-based unfairness? Evaluation point number 3 focuses on economic opportunity. This is where the law tries to strike a perfect balance between protecting a minor and giving them the freedom to start a career. The point. This exception is vital because it recognizes that if minors couldn't be held to their word, no one would give them an apprenticeship or a job. It opens doors to the professional world. The evidence. Look at the whole beneficial test from Doyle v. White City Stadium. The court is being pragmatic here. They accept that a contract doesn't have to be perfect. Even if it contains restrictive terms, like the no prize money rule for Doyle, it can still be binding if the overall result is that the minor gets educated or trained. Now for the critical analysis. While this is a workable arrangement for the economy, it can be incredibly harsh on the individual. Think about the long-term impact. A minor could sign a contract at 15 or 16 that binds them for years. Even if they grow up and realize they no longer want that career path, they might be legally stuck. If a court decides the contract is beneficial, the minor loses their right to walk away. It raises a tough question. At what point does a beneficial contract start to feel like an unfair trap? This is a great point to raise in your 25-mark essays to show you understand the tension between commercial necessity and individual liberty. Our final evaluation point looks at the effectiveness of the Minors Contracts Act 1987. For decades, the law was criticized for being too one-sided, but this act significantly improved fairness to adults. The evidence? Section 2 was a game-changer for the banking and retail sectors. By making guarantees enforceable, it allows adults to safely lend to minors, as long as a parent or guardian is standing behind them to foot the bill. Section 3 introduced the principle of restitution. This is designed to prevent unjust enrichment. Basically, the law says, okay, we won't make you pay for that motorcycle, but you can't keep it either. The minor has to return the goods to the seller. Now, for the critical analysis. Is the act perfect? Not quite. Notice that restitution is discretionary, not automatic. The court only orders it if it's just and equitable. More importantly, an adult trader may still lose out completely if the minor has already consumed the goods or spent the money. If a minor buys a big expensive meal or uses up a service, they can't return that. Unlike a standard breach of contract, the court cannot order the minor to pay damages from their own separate savings to make up for the loss. So while the 1987 Act helps, the legal shield for minors remains incredibly strong, and adults still trade with them at their own peril. And there we have it, the complete guide to minors' capacity for your 9084 Paper 3. Let's recap the high-yield points you need to carry into your exam room. First, remember the general rule. Contracts with anyone under 18 are generally unenforceable against them. This is the law acting as a shield against exploitation. However, you must know the 3 binding exceptions that can make a minor liable. 1. Necessaries. It's not just about what they need to survive, but what is suitable for their lifestyle. Remember Nash v. Inman. If they already have enough, it's not a necessary. 2. Beneficial contracts of service. Employment and training are binding if they help the minor earn a living. Use Doyle v. White City Stadium to show that the contract must be beneficial as a whole. 3. Voidable contracts. These are the long-term continuing obligations, like leases or shares. They stay on unless the minor repudiates them. Don't forget Edwards v. Carter. Waiting 4 years is way too late. Master these 3 categories and the evaluation points we covered, and you'll be well on your way to a top grade. Thanks for watching. If this helped you clear up the confusion around capacity, hit that like button and subscribe for more A-level law deep dives. Good luck with your revision.